welcome to today's webinar, due to last an hour, Universities and the Pandemic, Current Issues. In fact, we're dealing with two particular issues today. Firstly, I'm going to be dealing with mental health and pastoral care and legal issues which arise from that. You're then going to hear from Yaaser Vanderman about the quality of teaching online learning, and then from James Neill about private law claims against higher education providers. I'm Fiona Scolding QC, and I'm the chair of this session. A few housekeeping points for all of you. Microphones are automatically muted, so you don't need to adjust your settings. Secondly, we very much welcome questions throughout the session. There is a Q&A box. Please do write your question. We can't promise that we can answer all of them live, but what we often do is provide a paper after the seminar which seeks to try and answer the questions to the best of our ability. The webinar is recorded and you'll receive a link after the seminar has finished. And if your connection is lost at any point, please just re-click on the original link. And the last thing I would say is, if you see me looking slightly to one side, it's because my slides are set out slightly to the side of me this afternoon. Let us begin. So I'm giving the first talk, Pastoral Care, Welfare and Mental Health in Universities. And this is a topic which is dear to my heart and to everybody else's at the moment, given the significant rise in mental health problems amongst young people, both attending university and at schools. So I'm going to deal with two issues. Firstly, the duties owed by the university to provide pastoral care or welfare services. And secondly, some issues which can arise if you have students who are presenting with mental health problems, and issues which may, and I only say may, give rise to a claim for damages. Well, for the sake of the obvious, students, I think, very much feel like the forgotten within this pandemic. There are about 2.3 million undergraduates in UK universities at the moment, and about 600,000 postgraduates, 900,000 of whom are 20 and under. Now, I remember when I was at university, I thought I was terribly grown up and sophisticated. Looking at it from the other end of the lens, through having teenage children, I would say the idea of them at 18 being grown up enough to go away and live even semi-independently is something which fills me with fear, as they don't seem to be grown up at all at that age. And as we all know, their dreams of fun, creativity and independence have led to pot noodles in front of the TV with 7 people they don't like very much. Furthermore, those who started university this year have also had to contend with the cancellation of the examinations, not being able to sort of finish their school career, and all the uncertainty that the pandemic has brought, which, as we all know, significantly exacerbates underlying mental health problems which might be there. I think it's also worth bearing in mind, as I was sort of contemplating this at the weekend, that this is the generation who've grown up with the financial crash, austerity, the invention and what I've described the triumph of social media, although it might hopefully be declining somewhat, Brexit, global warming and this pandemic. So they've already had to deal with a significant number of concerns and issues which may well make them more anxious, more stressed and more depressed than possibly previous generations were. Furthermore, university is often the first time that young people are living away from home, although I'm not going to underestimate the significant number of students who do live at home. And certainly this term, the vast majority of students will be living at home at least until February, if not potentially beyond that, because the government guidance indicates that they shouldn't have moved back to their halls of residence or to their accommodation in their university town unless they have a good reason to do so. Now, what is a good reason varied, I think, from institution to institution. And bear in mind, the other mental health issue, which I think is often underplayed, is the dealing with the mental health of students who come from outside the UK. There's around 342,000 students who are non-EU nationals. And I've set out the various statistics there, and we have to realise that a number of these individuals are coming from different cultures where issues around mental health are dealt with very differently, and there may well be some linguistic barriers, particularly when it comes not to discussing, you know, points of university, but about one's feelings and emotions, and social barriers which needs to be particularly taken into account. Now, for all of those who are moving away from home for the first time, or moving away from home in circumstances where they're worried about their mum and dad or family members becoming ill, they will have problems which can give rise to mental health issues. So many students struggle, now this was pre-pandemic, struggled to maintain day-to-day routines, feel there are academic pressures, and I think those academic pressures will be considerably more at the moment because of the uncertainty about what's going on, and because their learning has switched to online learning almost exclusively for the vast majority of undergraduates and postgraduates in the vast majority of subjects. There's social and financial pressures. I do know that most universities have put in place additional hardship funds, but there are all sorts of pressures associated with the pandemic. And 18 to 24 is the likely age in your life if you're going to develop very serious mental health problems, things such as schizophrenia, bipolar disorder, those sorts of diagnoses, they are likely to have developed in you by your mid-20s. So I think there has always been, although it might not necessarily have been dealt with very well, there has always been a situation where people expect or know that university may well be a time when people's significant mental health problems will reveal themselves. So I've set out some factors that the Royal College of Psychiatrists identify may increase mental distress. And basically all of those factors are in play at the moment. So just a few statistics for you so you can see the extent of the problem. In 2017-18, the Office for Students stated that 3.5% of all full-time UK students, i.e. those who were domiciled in the UK, they hadn't come from abroad, had a recognisable mental health condition. Now there's going to be, you could say there are lots and lots more people who would not have a recognisable mental health condition, but at some point during their undergraduate or postgraduate career will require some additional support. The MHFA says that 34% of all students reported having psychological difficulties for which they needed professional help. And the Royal College of Psychiatrists in 2011 did a very similar study. In 2016-17, which is the last date for which we have reliable figures, 95 students took their lives in England and Wales. But it should be noted that, in fact, that is actually quite a significant reduction from the 1990s. So maybe some of the things which universities have been doing over the past 5 or 6 years have been working. And this is against a background of a significant number of young people meeting the diagnostic criteria for depression, which is, not just feeling a bit unhappy for a while, but requires DSM-5 to be met. And astoundingly, this was the first time I'd seen this figure, 26.8% of young people aged 16 to 24 reported having suicidal thoughts in their lifetime. And 9% of 16 to 24-year-olds have attempted suicide. So I think there is absolutely no doubt that university, leaving aside the pandemic, and the pandemic I think has crystallized and brought into sharp focus these issues, that university is a time of life for young people when they may well be developing serious mental health problems. They will not necessarily have the support structures around them to be able to manage those problems effectively, and they may well be confused, unwilling, or uncertain of where to go to seek help. And I think universities, certainly over the past 10 years, have recognised the central role that they have to play in these circumstances. So you have a student with mental health problems and everything goes catastrophically wrong. One hopes that that doesn't happen, but very occasionally it does. Obviously, a university owes a duty of care to students in the way that it delivers services, and that includes the provision of pastoral support and welfare services. And it is also responsible for taking reasonable steps to protect the health and well-being of students under the Health and Safety of Work Act. Now, the scope of this duty is obviously quite wide, but the breach, it will only be breached if, under the usual Boland principles, a university acts below the standard of a reasonably competent university. One of the issues with advising universities or students in this setting is there is relatively little case law, partly because pastoral services and mental health services were not as extensively and comprehensively developed prior to, say, the last 10 years. But secondly, because most students don't bring actions or don't bring complaints or don't issue concerns. But what is absolutely clear from all the guidance issued by the Office for Students, which obviously is the regulatory body for the higher education sector, but also by the government itself, is the primacy and necessity to put mental health issues, the provision of mental health services, right at the top of your agendas, strategically and practically. So there's guidance published about how to properly support students, and the university's minister wrote both in 2018 and in fact at the beginning of this pandemic to say that the well-being of students was a non-negotiable priority. So if you look at how a court is likely to say that will say that a university is responsible for providing adequate pastoral care services, and if that is breached, but what amounts to a breach of that duty is very much going to be fact and context dependent. And certainly so far, when it comes to claims in negligence, which have a mental health element, which James will be talking about later, universities are, I would say, probably given a relatively easy ride in terms of the scrutiny of what they've done or not done. But obviously, if you're talking about a student that might have taken their own life, a court is going to want to look very anxiously about what policies and practices were in place and whether or not a reasonably competent university would or wouldn't have taken those steps. So some other sort of current programs that you need to look at when you're looking at roughly, what would be reasonable for a university to do. There's the Universities UK Step Change Framework, which seeks to promote a whole university approach. The OIA's reports, which indicates that it has a growing number of complaints about mental health problems, about not dealing with those. And the OFS requires an access and participation plan that looks at and analyses the position of students reporting as disabled. And Universities UK certainly had set up a task force about information sharing with parents when students have mental health problems, which was due to report. I couldn't find that report. I think possibly the pandemic has meant that the publication of that report has been delayed. There's also guidance to help university leaders prevent student suicide, which was published by Universities UK in September 2018. And something which was drawn to my attention is studentspace.org.uk, which is a national web service funded, I think, by Universities UK and the OFS, which provides resources and advice and telephone support. It does have a search facility which should set out what it was, but when I put in various universities, it came up and said they hadn't filled their information in yet. So, but those are all kind of practical steps where you can go and find information and may well be useful If you are thinking that things aren't being run particularly well, or you're worried as a university administrator that you're not doing what you should, to look at what the general principles are. But they are very much, most of that guidance, if you look at it, is at a very high level and is not at a level of granular detail about exactly what should be done by whom and when. And again, the most recent guidance on coronavirus, which has something about mental health in respective universities, simply says there needs to be pastoral support, but doesn't identify what and from whom, and simply says work with the NHS, and says that additional funding has been made available for student hardship. So it's not wildly helpful in terms of what you should be doing. And as I'll come on to say, there are some significant concerns. I've already said that there are specific duties owed under the Health and Safety at Work Act to take reasonably practicable steps, breach of which could give rise to a potential civil claim, or in some cases a potential criminal claim, although the Health and Safety Executive has to date not necessarily focused upon mental health failings when it's exercising or making decisions about its prosecutorial powers. So as a university, you need to show that there are sufficient systems in place to manage and support the mental health of students. And I set out in this slide the general rules for having negligence. So there has to be an assumption of responsibility. There has to be reasonable foreseeability of injury, and it's fair, just and reasonable to impose a duty of care, something which in the context of the relationships between a student and a member of staff of the university is likely to be clear. Now, obviously, if you are going to be imposing the assumption of responsibility, or there is a need for everyone to be aware of mental health issues, I think what you have to think about is whether or not the current level of training and support that you give to staff who act in a pastoral manner, not necessarily specialist counsellors or therapeutic staff who you might employ who may well have professional qualifications, but sort of tutors, sometimes student volunteers, all of whom provide kind of pastoral help and support. Do they have regular training? Do they have regular debriefs? Have they had training in identifying and knowing what to do? If you run a counselling or a welfare service, every university runs a counselling and a welfare service. Some of them are more sophisticated than others. Then individuals working in that service are going to be judged against other professionals doing that job. So you need to make sure that they have had appropriate training, that they're appropriately qualified, and that they understand the particular issues which take place in a university as opposed to other settings and are familiar with young people. So I would say that the most important thing is to have a comprehensive strategy and policies and processes, because if ever there are questions about negligence, the first thing the court's going to say is, well, do you have a policy about this? Do you have a process? And has that been implemented? So I think that accessible to all staff, and I would say that's the cleaner up, because the reality is that if somebody does do something terrible, people like cleaners, catering staff, bar staff are usually security staff, are often, certainly absent young people unfortunately being locked down and basically being stuck in their rooms, likely to be the people who are going to notice people who are becoming quite seriously unwell, and may well and are basically your early warning system for when things might be going horribly wrong. Because whilst young people are much better able to deal with and manage mental health problems, and most young people are much better able to identify them in their friends than they would have been, they often don't know what to do about them. So adults who are contractors, agents in the university are likely to be the people who are going to have more idea of what you do. So there should be clear processes in place about what to do if they find somebody who has tried to hurt themselves, who they think is going to hurt themselves, or are likely to cause a risk of harm to themselves and others, or are demonstrating significant signs and symptoms of mental health problems. And the message, I think, should be, if in doubt, refer, and there should be a clear pathway so everyone knows who to speak to, who to call, who to escalate up the chain of command. Particular issues might lie if students arrive with particular mental health conditions. So there are issues which you're going to need to think about, which is if you know that somebody has anorexia nervosa, for example, something which is a particularly pernicious and deadly mental health condition. It causes more deaths in young women than any other I think all other mental health conditions put together. So, for example, do you make sure that the catering staff know that that's the position? Do you need to have a conversation with that young person to say, look, we would like to be able to keep an eye on you in that way? Do you make sure that people in libraries, cleaners, security staff, catering staff know that that's the position so that they can keep a weather eye out, making sure that the young woman, not just young women, but largely young women, aren't getting too thin? Have staff had training to spot concerning signs? Do they know where to signpost the student and who to tell? Do they know how to phone the police, mental health? Do they have an emergency community mental health number that they can phone, or does someone on site know that? If they have no known concerns, then I think there should be discussions with students, obviously subject to the University UK's views about it generally, about whether or not students in some cases should sign consent forms, providing they've got capacity to do so, so that universities are able to tell parents, carers, siblings, others, if they've got a history of mental health problems, or if they develop that, if they're at risk of becoming unwell. As you will all know, Bristol University, there was a spate of suicides there 3 or 4 years ago. And one of the things that came out of that was the fact that the parents said, but we didn't know. And of course, once somebody is over 18, there is no reason why they would know. But certainly for those who are coming to university with already known or established problems, you might want to at least initiate that conversation or have a discussion about whether or not they would want mum and dad to know if they started to become unwell. So concerns, I think, which arise specifically from the pandemic are there aren't sufficient eyes on the students. As I've said, most of the early warning systems are not in place. If somebody is very mentally unwell, you can't tell that on Zoom as well as you can in real life. And things like cleaners aren't going to be going in as much, catering staff aren't going to be seeing them, librarians, libraries are shut. With everything being shut, a lot of the signs and symptoms and ways that you pick up people being unwell, somebody's just sent me something identifying that. Furthermore, unfortunately, lockdown leads to more withdrawal, more isolation. And therefore it can become difficult to work out what's just a natural sequelae of the pandemic and maybe a rational fear about infection, and what becomes that. I mean, certainly I think that every university should be undertaking proactive welfare support online. That's websites, Q&As, helplines visibly posted around anywhere that students will be, sent to them by email. Keep in touch for those who have pastoral responsibilities, even if that doesn't usually happen. So I would say phone calls, video calls, regular checks. How are the students getting on? How are they behaving? Peer referral, I think, becomes very important. I think certainly, as I suspect this is going to go on for a while, unfortunately, if you haven't already done it, sort of skilling up members of the JCR, members of the Students' Union, to have peer referrals, dealing with those at home who are displaying problems, because obviously the vast majority of students are now going to be being educated at home, and also trying to manage the mental health of those who may well be living overseas who haven't been able to come back. So alongside tort duties, there are contract duties, which Yaaser and James will go into in more detail. But if I would say, there is an expectation that pastoral and support and welfare services will be provided by every university, and therefore the contract should cover that. And in particular, the areas where I've certainly been involved, deal with health issues that may impact upon a student's progress, which is fitness to practice, academic outcomes, so that's exams, assessments which are impacted by somebody's mental health, and disciplinary processes which arise because of individuals' behaviour which may well have been caused by underlying mental or physical health problems. So I suppose there's two things that I would say. Firstly, make it clear what's being offered. Secondly, offer it. So the main problem, I suspect, that has arisen is firstly the shortage of services, and secondly the inability to deliver services because of the pandemic. Plainly, in a contractual situation, you obviously have the mechanism of frustration. So if you can't deliver the services because of something which is wholly beyond everyone's control, then that part of the contract is frustrated. Likewise, you can't physically recruit more people if everybody's off sick. Well, you can, or you can try to, but there are issues about, are staff being put on furlough when maybe they shouldn't have been? Does this expose some significant difficulties with the counselling service as a whole? There's likely to have been a massive increase of referrals. To make sure that any contractual terms you have simply say there is a reasonable endeavour to do so, and that there cannot be guaranteed provision of the service. The other thing I would say is that university services are going to be under a significant strain, largely because the NHS is absolutely buckling under the weight of the number of mental health referrals. So even if you've got very serious mental health problems, you may well not get a referral to see somebody for 3 or 4 months at the moment. So, you know, it's particularly important that universities are keeping an eye on students at the moment, because there can be no guarantee that the NHS will be able to deal swiftly and as effectively as they would like to with the sorts of serious mental health concerns that students can present with at this time. The other issue, just to raise very briefly, is obviously there are duties that the university owes under the Equality Act, and mental health impairments which do not need a clinical diagnosis can be a disability if they have a substantial and long-term adverse effect on somebody's ability to carry out normal day-to-day activities. Now, that is a pretty low threshold. Substantial meaning something which is more than minor or trivial, or something which has either lasted for 12 months, likely to last for 12 months, or likely to reoccur at some point in the future. And something's likely to reoccur if it could well happen. Now, the literature is absolutely clear that if you've had one episode of mental health, the likelihood of you having further episodes goes up significantly. So I think it is highly likely that a large numbers of students would fall into being disabled students. And therefore you as universities or students need to know that there is a duty not to be discriminated against. The most likely duty which is going to arise would be under section 15 of the Equality Act, which is discrimination arising in consequence of disability, which cannot be justified. And obviously the other duty which is likely to be in play is whether or not reasonable adjustments have been made to the provisions, criteria and practices, or to the auxiliary aids. Now, in mental health conditions, that's likely to be, have you been given sufficient time, extra time, if you've got problems, if you've got depression and anxiety, is there a dispensation available? Are you being penalised unfairly because of your mental health problems in terms of your academic progress? Are you being provided with the appropriate support? One of the major concerns that most public bodies have is reasonable adjustment is not defined. It is anticipatory in nature. So for common mental health conditions, you would expect services already to be in place in the university which can be used. You can look at the cost of taking steps and resources, and the need to maintain standards, health and safety, the interests of other students. That's not an exhaustive list, but those are examples, but they all have to be weighed in the balance. Obviously, universities are also public bodies and therefore have responsibility under section 149 of the Equality Act 2010. Equality Act claims must be brought within 6 months of the Discriminatory Act, and there can be county court claims. It's exclusively the province of county court claims for claims in discrimination, other than if you want to judicially review the local authority. There are also obviously data protection issues which arise in this context. What I would say is obviously anything to do with somebody's mental health problems will be sensitive personal data, but such information can be disclosed in certain circumstances, either where consent has been given or there is a serious risk of harm to that person or that person lacks capacity. And what I would say is my experience has been that public bodies post GDPR have become more reluctant to share information than I think they necessarily need to be, both about young people, but also about those at university. If you are seriously worried that somebody is going to take their own life, it is, I would say, your responsibility to tell somebody else. And both the GDPR and the basic common law of confidentiality permit there to be exceptions in cases of necessity. So I think there are circumstances in which you can breach confidentiality if you have serious concerns that somebody is going to harm themselves or try and harm somebody else. And so I just sort of say that because I've come across situations where there's been a marked reluctance to do so. And I think there needs to be a slight reweighting of those scales. There's also obviously the issue of coronial proceedings. I just do a slide on that. Universities are not meant to be a substitute NHS, but the government, it does encourage universities to enter into formal arrangements or projects with NHS staff, seconding them to the service, having NHS staff on campus, running a GP practice on campus, having drop-in sessions with nurses. And I would certainly urge all of you to have partnerships, specific framework agreements and partnerships in order so that your students can have access to NHS services, or that specific services in your area can be developed with the local authority and with the NHS in order to meet the particular needs. So what I would say is I think the pandemic provides us with a real opportunity to look holistically about the provision of mental health care in the future for universities. Firstly, I would advocate for comprehensive provision of on-site specialist facilities in all large campus universities, because I think it justifies it, and I think work with the NHS or work between the NHS and universities, it can't be beyond the wit of people to set up those sorts of facilities. Routine partnerships with local mental health NHS trusts and community services, rethinking the way that services are delivered, and making sure that you have a governance and strategic focus at the very highest of levels on your board of governors about mental health problems. Because I know that given all the issues which have arisen over the past year, especially to do with money, it may have slipped down with the agenda. And most importantly, engaging with your student population about what services they would like to see in respect of pastoral care and mental health support. I've run, per usual, slightly over time. I will try and answer the questions at the end, but I now pass over to Yaaser, who's going to deal with the quality of teaching and online learning. Thank you very much.
Thank you so much, Fiona, and thanks everyone for joining. I'm going to be talking about issues arising from the impact of COVID on teaching, moves to online learning, that kind of thing, and methods of redress. Now, I'm aware that we have students and universities and firms who represent both sides, so I hope there's something here for everyone. This is what I will be covering. First, just looking very briefly, the legal framework, because I think that's a useful backdrop. Then looking more at the Office of the Independent Adjudicator and some issues around that. Then looking at complaints to OIA and focusing on specific case studies that have arisen over the last few months, because I think that provides a really useful, valuable tool for both students and universities and everyone to understand when the OIA will intervene or make recommendations, and then finally looking at judicial review and the options there. So these are much more public-facing claims. I'm not going to be focusing on private claims. James will look in a bit more detail at private claims. I'm going to be focusing on these areas, which may be the most attractive to students and which universities inevitably will be faced with. So looking firstly at the legal framework in this area, I'm going to cover this quickly because I suspect many of you here just find out what the practical reality of the current situation is, but I think it's useful and helpful to understand the overall process. So the legal framework between students and their higher education institutions is frankly not straightforward. Most obviously, you have a contract with the university, but given the fact that universities are also effectively public institutions, you have relevant public law principles that come into play as well. So, for example, universities can, in principle, be challenged in the High Court by way of judicial review for public law errors they make. We'll see a bit more on that later on, but in principle, that's the position. And then finally, there is a layer of statute which does many things. For example, not relevant to this talk, but there are legal obligations on universities in relation to free speech on campus. There's one example of how that statute overlays everything else. In this context, the statute is relevant in the following way. The Higher Education Act 2004, and that established a complaints scheme run by the OIA, the Office of the Independent Adjudicator. And just very briefly, it defines qualifying institutions, i.e. those who qualify for the scheme have to abide by the scheme, very widely, basically every university and every registered higher education provider. And then it defines qualifying complaints extremely broadly as well. A complaint about an act or omission of a qualifying institution made by a person or student, but crucially excludes academic judgment, but otherwise extremely broad. What is the relationship between the OIA and the High Court? In other words, if you're a student, can you choose between those two routes? Are you forced down one route, assuming that you want to stay out of private claims for a moment? And we virtually see the answer in the case of Zahid, and that case involved complaints against expulsions of students from university. And in that case, students brought both at the same time, essentially. And there, Mr. Justice Hickenbottom essentially said, your first port of call should be with the OIA, unless there are good reasons not to do so. But I should say that is in the context of whether you're bringing a JR instead, not necessarily whether you're bringing a private law claim. So let's move on to the next slide. So looking at the OIA in more detail, useful to look at the rules briefly. Some things to note. You can complain to the OIA about basically anything. You see that in the first bullet, rule 4.1. Excludes academic judgment, as we've already covered. Very importantly, it is free, no fee to complain, and no fee if you lose. If you don't get a recommendation, or you get a recommendation against you, there's no costs liability. Very importantly, the OIA will not review the complaint unless the provider has considered the matter first through its internal processes. You can't go straight to the OIA. You have to first exhaust the processes of the university or provider before going to the OIA. There are exceptional circumstances in which you can bypass that route, but I think mostly that won't be the case. And then the process is usually heard on the paper, so very unlikely for there to be a hearing where someone turns up and makes the arguments, mostly on papers. And in terms of timeframes, you see there, within 3 weeks, there will be confirmation from the OIA about whether it can review the complaints, and the final decision is normally made within 90 days of receiving all relevant documents. So not too slow, not too bad. And what has the OIA said specifically about COVID? I came out with a briefing note in June, which made for some very interesting reading. Because if you were a cynic, you might think that it would give huge leeway to this sector, or you might indeed be fear that because of COVID and because of unforeseeability, this huge impact on every aspect of society, that it might try to insulate universities from the impacts of COVID and lockdowns, etc., on their courses. But in the document, I actually see a very balanced picture. Now, of course, it's going to give some leeway to universities, but you also see here some relatively strong wording from OIA in this briefing note. And you can see in the underlined section, providers should be planning to deliver what was promised or something broadly equivalent to it. it's unlikely to be reasonable not to do that, especially now the initial crisis period has passed. So I think the point being made is that universities have had time to put in place some mitigation, some alternative provision. And the last section there, where providers have not or decide they cannot deliver what was promised, they will need to consider how to put that right. And this is important. A blanket refusal to consider tuition fee refunds in any circumstances is not reasonable. So you see the OAA putting in that. On exclusion clauses, you can see here what it says, i.e. clauses in the contracts between universities and students which say something along the lines of, the university is not liable for your course changing fundamentally partway through the year. That kind of thing is not going to be okayed. It's going to receive very close scrutiny by the OAA. And then on course delivery, again, some interesting comments from the OAA. Focuses on reasonableness. Essentially. Whether what the provider has done is reasonable in given to the university. You're not going to get completely off the hook because of COVID, but we're also not going to pretend that COVID doesn't exist. So the question is, did you take reasonable steps in the circumstances? And we'll see more of this later on when we come to look at the case examples. And based on those examples, we're about to look at some case studies of how the OIA has come to some decisions. But before we do that, I want to emphasize the factors that it has concentrated on. So you see here 5 of those. First, whether the provider acted reasonably in treating the student fairly. Second, what the provider did at the time to minimize disruption for students affected, to try to put things right. Third, what the provider promised and what the student could reasonably expect in terms of contact hours and other learning opportunities. Fourth, what the provider did to ensure that the students were not disadvantaged academically and could achieve their learning outcomes. And finally, what the provider delivered and whether that matched what was promised and what students reasonably expected and was broadly equivalent to its usual arrangements. So those are the factors. And whether you're a student making a complaint or a university defending one, use these headings when you make your reps. This is what the OA is looking for, so why not give them what they want? And we'll see in the case studies, students have lost because they haven't sought to address all these points. So yes, the university may have fared badly, in the second bullet, but the others weren't criticised by the student, and overall, the approach was okay. And equally, if you're a university and you're looking forward to make sure your approach in the future is beyond reproach, why not structure it around these bullet points? Use them as a checklist because we know that this is what the OIA is interested in. So the OIA released 10 decisions in November relating to COVID. They're anonymised, so we don't know what universities they relate to, but they are an invaluable resource for students and universities seeking to understand how they should approach the process and also likely prospects of success. And you'll see there's not all one-way traffic. Some success for students, a bit more success for universities, but the big takeaway, and perhaps not a surprise, is that it all depends on the detailed circumstances. So let's have a look at them. This is the one case that was justified in its entirety, i.e. the student won. And you can see that the complaint was studies were disrupted due to industrial action and further lessons were lost due to lockdown. And the complaint from the OIA, the complaint was justified here because the OIA basically said the university didn't provide us enough information to decide what it had done and whether it was reasonable. And here the complaint was upheld that the provider hadn't engaged with the students' individual concerns at all. And so we couldn't reject their complaint, but here they basically sent back the university to provide more information. Moving then on to the second, this is one of the partially justified cases. This is perhaps the most interesting because it's the only complaint where a refund was recommended. And you can see it involved an international student who paid quite a lot of money before university cancelled half of its on-campus learning due to lockdown. And there were 2 modules in dispute. First, the OIA basically said we were satisfied that the actions the module leader taken mitigated the disruption to the learning opportunities and ensure that delivery was broadly equivalent to usual arrangements. But then see what happened in the second module. You can see that much teaching was just cancelled without replacement. Projects were got rid of. And you can see the conclusion was that the provider had not taken sufficient steps to mitigate the disruption to the students' learning experience or to ensure delivery was broadly equivalent to its usual arrangements. So what was the outcome there? Well, three things of interest. One is £1,000 was a refund was recommended. And the second is the method of calculation. You can see the starting point is the cost of teaching hours missed. Then you add loss of the project. And then you minus a discount for the facilities that university has to pay for, and also the fact that you still had access to remote services. And then the third interesting point is why the refund was ordered. And it's because much of that second module was essentially abandoned without replacement. And so if unis want to avoid this sort of situation, they'll need to show at least some sort of replacement, even if not like for like, was put in place to mitigate the loss of face-to-face teaching. And then the other partially justified case, you can see that it was a health-related cause disrupted by industrial action and then also lockdown. And here you can see another example of a university failing to engage with the process, and we see the same response from the OIA. Basically, go back and start again. Lesson for the university here: engage with the process, show your marking, to show that you've done all you could in the challenging circumstances. And then you have 2 or 3 not cases, complaints that are found to be not justified, rejected. And here you have an example of a university that did quite a lot to mitigate the impacts on students. You can see it in those bullets there. Lesson for the students here, the mere fact that you are losing face-to-face teaching will not be enough. The OIA will be looking in detail at how did the university make services available, how did it communicate this with students, what was the effect on learning outcomes. The mere fact that you go to online teaching is not going to be sufficient for a complaint to be upheld. And we see a similar picture in the other rejected complaint, similar story, but there also you can see that there was a lack of access to facilities as part of the complaint. But interestingly, it doesn't look like loss of access to facilities counted for much in the OA's mind. And you can see that the university did provide other services. The library and other services were available online. Student support and wellbeing services continue to operate. And then here you have a series of 3 cases where the complaint was found not to be eligible for the complaint scheme. And these were for pretty straightforward reasons that mostly we've covered. A student hadn't complained to the provider first, went straight to the OAA, can't do that. Student complaints, the provider was at the final stage of internal processes, so again had to exhaust that process. And finally, technical point, the course was a level 2 course and not a higher education course. So there are some courses which the OAA complaint scheme you won't be eligible for. Finally then, JR is relevance. What to do if you're not happy with the OAA decision? Well, you can challenge it in the High Court by way of judicial review, and otherwise you'd be saying that the OAA has made a public law error in coming to its decision. What does that look like? What does a public law error look like in this context? Well, any number of public law errors. Quintessential public law argument is that the OAA acted irrationally, but that's likely to be a very difficult argument here. Other points might be of more benefit. You could say it took into account a legally irrelevant factor, or took into account, failed to take into account a legally relevant factor. And just by way of example, take this case. You might remember we looked at it. It was the one where a refund was recommended for £1,000. And if you look in that underlying section, you could argue that in coming to its decision, the OA took into account an irrelevant factor, i.e., not completely clear what the OA is saying here, but it could be the case that it's saying the cost the universities have to bear in providing and maintaining facilities, infrastructure, admin, etc., should form the basis of some discount. And that seems to be separate from the argument about remote services being available. So you could argue, why should a student get less of a refund just because the university has certain fixed costs? And if that's what the OA is saying here, then you could argue that was a legal error. But that just gives you one example, not necessarily unbeatable argument, but just the kind of thing you might argue on a judicial review. Other very important point to note about JR, significant cost to bring such a challenge, not just your own lawyers, court fees, but also the fees of the other side if you lose. They can be very significant. And also bear in mind, the court is going to give a large amount of deference to the OIA, the expert body. So any claim is unlikely to be easy. So that's my talk. Sorry, I've rushed it a bit, but hopefully I've got down the main points. I'm now going to pass on the baton to James.
Thanks, Yaaser. So for the final 10 minutes or so that we have left, I'm going to address the issue of private law claims against higher education providers. This is necessarily going to be quite a quick canter through the various claims that might be brought against higher education providers in light of the pandemic. But I'm really going to focus on two areas where universities and higher education providers may find themselves facing liability in either claims for contract or torts, and that's broadly the claims regarding educational provision, both in the sense of not providing those services at all, where they haven't been able to be provided, and in the sense of where they have been provided, but they haven't been provided, so it is alleged, up to the requisite standard or adequately. And then very briefly at the end, I'm going to look at the question of claims against higher education providers in respect of accommodation. Now that particular area could take up an entire seminar in itself, but we felt that it wouldn't be right to not mention at least the some of the issues that are going to arise when trying to when students seek to claim refunds for their accommodation fees, whether particularly in halls of residence. So with that in mind, I'm just going to look at my first slide. Should come up. Yeah, these are the three categories of the type of private law claims that arise in relation to educational provision, which was set out by the High Court in the case of Sadiq, or at least confirmed in that was the case brought against the University of Oxford, which I'll come on to. But broadly, the courts have recognised that there are three categories of claim and this category of claim, which have various ramifications for the issues that need to be established with those claims. So category one, claims asserting a breach of duty in the exercise of academic judgment. Now, it's been well established that those claims, of course, are not justiciable. That was confirmed in the case of Clark and in subsequent authorities. But of real interest for today's purposes are categories 2 and 3. And those are claims which might allege negligent teaching methods in devising courses, or importantly, delivering those courses. Now, those claims the courts have recognised are actionable in principle. And then we have third category, which is claims regarding operational negligence in making of educational provision. Now, the distinction between those two final categories is important, because where you're alleging a breach of a negligent teaching method, or in the way in which courses have been devised, then there'll be the requirement to produce expert evidence to show what the standard is by reference to what the established body or the profession would expect in respect of meeting those standards. Whereas a claim regarding operational negligence in making educational provision, so effectively administrative failures, wouldn't necessarily require that sort of evidence. So just having a look at claims regarding, or claims of negligence regarding the delivery of courses and negligence teaching, just have a look at this in a bit more detail. The case that established that such claims are actionable in principle is the well-known case of Phelps. And I've just set out the key extract there, which makes it clear that persons exercising a particular skill or profession owe a duty of care in the performance to people who it can be foreseen will be injured if due skill and care are not exercised, and if injury or damage can be shown to have been caused by the lack of care. And you'll see at the bottom of that extract is confirmation that a doctor, accountant, for example, an engineer are playing such a person. So in my view, is an educational psychologist, psychiatrist, or teacher. So there's no real doubt that the such claims can be brought. Now, importantly, if the attack is on the competence of a university's performance in the exercise of that skill and care in that profession, the merits of the claim have to be assessed by reference to the Bonham test, and that's confirmed in Siddiqui. And that in turn, means that you're going to need expert evidence to show that test is that standard hasn't been met. And I've put in this on the slide the case that made that clear, Abromova. So if we can move on to the next slide, please. What I'm particularly interested in, I think for today's purposes, it's quite interesting to explore is claims based on operational negligence. So that's where the claim is effectively a failure, administrative failure in the making of education provision. Now, the reason that's going to be relevant is because following the pandemic and the restrictions that have been introduced, clearly they're going to be, when results come out and when degree results are announced, as they have been in the summer and down the line, then one will perhaps expect to see claims brought on the basis that a failure on the university's part to make adequate education provision has affected the exam results. Now, the critical point here is there won't be any need for expert evidence. It will simply turn on the facts as to what was expected of the university in those particular circumstances. But whilst there'll be difficult questions of what the actual loss will be and how do you quantify a loss flowing from a lower than perhaps expected final degree result, what's quite clear is that is a foreseeable loss. No matter how difficult the task of the court would be to quantify that sort of claim, it would clearly meet, or the courts have held that sort of loss would clearly be foreseeable, and that was confirmed in the case of Wynne Stanley and against the University of Leeds. So we can expect to see downstream, and particularly because of the long limitation periods, 3 years in the case of claiming negligence, one could perhaps expect to see a spike in cases of students dissatisfied with their degree results and claiming that there has been that as a result of the failure in the circumstances to provide sufficient educational provision, notwithstanding the restrictions or the COVID restrictions in place at the time. If we can move to the next slide. So the key case here, and the only case that looks at this in any real detail, certainly the most recent, is the case of Siddiqui in the University of Oxford in 2016. Now, there are two judgments here that are important to have regard to. You have the Strikeout Judgment of 2016, and then the full judgment in respect of liability in 2018. The Strikeout Judgment, I've given you the reference at the top, is actually the most important, most useful, it seems to me, in establishing the way in which the courts will have regard to these sorts of claims, which include allegation of poor teaching due to, for example, the unavailability of sufficient teaching staff. Now, what happened in Siddiqui is quite an unusual claim in that the degree result was awarded in 2000 by the University of Oxford, but the claim was only filed in 2014. There was internal correspondence that the university, between the tutors, was aware of inadequate teaching provision in 2000, but the claimant only became aware of this in 2013 after discussions with other students. Now, in the Strikeout Judgment, the court held that the insufficiency of teaching capacity and alleged failure to remedy it could be or should be decided at trial, and that it had a reasonable prospect of success. There were clearly detailed limitation issues, particularly on the facts of this case, given how long the claimant had waited before bringing the claim. and in particular the point at which he had sufficient knowledge for the purposes of Section 14 of the Limitation Act, and whether for the purposes of Section 32 there'd been any concealment of any fact relevant to the claimant's right of action. But the important point and the takeaway point from this case is that insufficient teaching capacity is a justiciable issue, and so therefore needs to be may well come up down the line, downstream, as students receive their results over the next 2 to 3 years. The important practical point here, and the one that you take away from Siddiqui, is that internally, staff within higher education institutions have to be extremely careful about internal discussions about the adequacy or otherwise of the provisions that they are making during the pandemic. So it won't be it won't be sufficient merely to rely on the pandemic and say that that excuses any failure to make adequate provision. The courts will look at it in the circumstances. Clearly, they'll take into account the existence and of the pandemic and restrictions that those place on higher education providers. But it seems to me that where providers need to be very careful now is in what they're saying internally regarding their views on that provision, because in Siddiqui, that's what led to the case moving forward to trial, with some pretty unhelpful correspondence internally between the tutors concerned, where one tutor in particular, in effect, said, "I think we are laying on inadequate provision." In that case, it was because of the tutor to student ratio in particular tutorials. So quite an important case, if only to demonstrate the risk that arises in these sorts of instances. If we can move to the next slide, please. Thank you. Now, moving on to what actually happened at the trial of Siddiqui, the question it raised, well, how do you actually establish what a reasonable standard of teaching is in any particular case, particularly where you're talking about educational provision and the number of classes, sizes, and staff to tutor ratios, and the level of supervision given to students in any particular case. Now, what's quite clear is the court is going to take quite a generous approach to universities in this respect, if Siddiqui's anything to go on. The court said, well, we can look at what had gone on before, but in this particular case, the judge noted that the university in that case was clearly laying on a pretty gold-plated standard of education, and therefore said a cautious approach should be adopted to ensure, when comparing the previous position to what had actually incurred, that no counsel of perfection is actually imposed. When looking at the students' individual results, clearly proof of underperformance isn't going to be enough, and that was made clear at paragraph 89. And then, and the real killer for these sorts of claims, or the real hurdle that's going to be faced by claimants, is the court in this instance said it's going to be impossible to demonstrate the causal connection between the breach of duty and the poor exam result on these particular facts. So there are a few takeaway points that can be brought out from this judgment on liability. But the main point to stress is that the court in this case, and the judge in this case, took a pretty generous approach to the way the university had gone about making its provision. I'm conscious of time, so I'm going to just briefly now conclude by looking at if we can move to the final slide, please, the possibility of other contractual claims brought by students against higher education providers. And this really relates to student accommodation, which is obviously it's a critical issue. It's in the news at the moment. I've really focused on this slide on the situation with the university-owned accommodation halls and halls of residence, not private rental agreements between students and private landlords. Any license that has been entered into between a student and a university, it's like any other contract, the first point, the starting point, is to have a look at whether there are any force majeure clauses that apply and that apply to, that are included at all. If not, the common law doctrine of frustration, as Fiona mentioned, is likely to be relied on. And I put up on the screen there a reminder of what the basic definition of frustration is from Davis Contractors. Now, for those of you that are advising on this sort of issue in terms of accommodation, there is some quite useful material, and I recommend the starting point should be looking at treacle on frustration, because there's some quite useful chapters on, particularly in respect of leases, how the doctrine of frustration applies to those. Now, clearly, licenses are different to leases, but the courts have confirmed that in national carriers that frustration, certainly the doctrine of frustration applies to leases. But in the particular discussion in that authority on leases, there's some very good examples of where restrictions of freedom of movement were found to have given rise to discharge of a contract on the grounds of frustration. Now, I would have thought that those authorities are going to be relied on in any claims for refunds, or rather in any claims brought by universities against students to pay for student accommodation. I would have thought that there'll be a litigation that will cite those particular paragraphs of treacle. But those are the points to, or that particular extract of treacle I would have thought would be a useful starting point for anyone who needs to look at this in more detail. There are clearly complex issues regarding partial impossibility. You might have a situation where accommodation and halls of residence are still open, but certain services aren't provided within those halls, and clearly the period of time in which access is or isn't possible. But it's impossible at this stage to, for the purpose of this talk, to look at every single different scenario. But I hope that provides a starting point for anyone who needs to look into this in more detail. There we are. That was a very quick canter through of the other contractual claims, and particularly student accommodation. Finally, I should add that in terms of failure to provide services at all, whether they're educational services or accommodation services, full stop, there are clearly rights under the Consumer Rights Act, Section 55 and Section 56 of the Consumer Rights Act, which would give remedies to students as consumers. I haven't got time to get into that in any detail, but again, there is some quite useful. There's some useful guidance from the Office for Students, pointing both providers and students to CMA guidance on this, which confirms that universities, of course, are bound by consumer rights legislation. But for present purpose, I don't think we have too much time to get into that in much more detail now. It's 5:12. We've slightly overrun, but I hope we've now got time for some questions. And I'll now hand you over to Fiona, I think.
Yes, thank you so much, Yaaser, and thank you so much, James, for those very enlightening talks. Just to say to everybody that as a result of discussions we've had about accommodation amongst the group, we are going to be running a separate seminar in the next few weeks about property rights in universities, dealing both with private rented accommodation and also with halls of residence, to explore in more details those issues which James has raised, particularly as I know there have been and there will continue to be a number of rent strikes organised by students' unions, and I think the NUS might even be agitating for a national rent strike as a result of concerns around students having to continue to pay rent on accommodation that they are not occupying. So we're going to try and set one of those up. Watch this space. We will send you an email There are two questions, both of which I think probably came out of my talk, which I will try and answer, but Yaaser and James, please feel free to chip in. Firstly, saying it's often difficult to establish a duty of care on public bodies when the alleged fault relates to a failure to act. Will the precedents that have been established in relation to other public bodies, for example, the police, apply to universities? Well, I would say yes, because obviously much depends upon the statutory underpinning, the statutory backdrop, the way in which a service operates. But it seems to me issues in terms of whether or not to impose a duty of care for an omission in respective universities is going to be the same as it is for most other bodies that operate public sector liability, so to speak. So yes. And secondly, don't forget that certainly in respect of issues arising from mental health, if there's been an assumption of responsibility in terms of the provision of services, then undoubtedly under the Health and Safety at Work Act, there is a duty for students to be provided with for reasonable steps to be taken. So if reasonable steps aren't taken, then that in and of itself could found a claim in negligence. The second question we've been asked are about universities being public authorities for the purposes of the Human Rights Act. Somebody says, I've seen it assumed in a number of cases, but I'm also aware of coroners concluding that universities are not public authorities. Well, I think there are two separate issues there. A university is undoubtedly a public authority, or it is because it's providing a public service, the provision of education, or at the very least is a hybrid public authority, i.e. for at least some purposes, it's acting as a public body. But there is a distinction between if it's a public body and whether or not it's going to owe a duty for there to be an extended inquest under Article 2, you exercising the coronial jurisdiction. And certainly my view is I cannot see on the basis of the authorities at present, and there have been a couple of Supreme Court cases over the past year following on from Savage, that it would be the case, and Court of Appeal cases, that it would be the case that the failures of universities in the provision of mental health provision would amount to the university taking such control of the situation as to be in the same boat as NHS services if they're looking after people who have been detained under the Mental Health Act or have been shortly afterwards been released and then taken their own lives. So I think there's a distinction there. Yaaser and James, do you agree with me as far as the general principle that universities are public bodies under the HRA?
Mm-hmm.
Yes.
Yes.
Good. I mean, there might be a couple of sort of solely private universities, but I think even they, in as much as they're exercising the public function of providing higher education, would be acting as public bodies in that respect. So the last question we have is, somebody says the student contracted for an in-person course. They received an online or substantially online course. Can the students claim the difference between the market rate for an online versus an in-person course, approximately £3,000 being the difference? Now I'm going to pass this over to Yaaser and James.
Well, you saw from the in terms of our little complaints to the OIA, where James thinks of the answer for the private claim. In terms of the OIA, we saw that the mere fact that you've been in the circumstances of COVID, many services have been teaching has been moved online rather than in person. That in and of itself isn't going to be enough to give you substantial recommendation. The case for a refund, those cases are often where the course has simply been cancelled without much of a replacement. So that's probably the way. I mean, it'll obviously depend on the details and exactly what the difference was, what access to other services were given online. But I think generally speaking, it'd be more difficult to get that market difference by OIA route. James, do you want to talk about private law angle on that?
I mean, I think it would be difficult automatically, because I think you have to look at the section 56 of the Consumer Rights Act, because that's going to be the main remedy there, because the which effectively says that if you've been provided something, if you haven't been provided it with a service, and then it's impossible to supply that service, then effectively you should be entitled to a refund. Now the question is going to come down to whether the provision of the online service in these circumstances is not the re-provision of that service, and that hasn't been tested. And I think the CMA, the OFS guidance, and which refers to the CMA guidance, the CMA has refused to categorically say, as far as I'm aware, whether or not in those particular instances refunds should be processed. But that's the route to go down through the Consumer Rights Act and that sort of case.
But I think the individual who sent the question in said, which is the difference between the £9,000 tuition fee for in-person and the cost of an open university course fee at £6,000. But of course, what the university would say was, well, we weren't making the provision as set out in the Open University. You have got the provision from X university. And I think it would be very difficult, if not impossible, or the OAA, I think, will say, we're not going to compare like with like. We're not going to compare online courses which have been designed as online only, or things like the Open University, which are deliberately designed as kind of part-time extension courses, largely video based, with the circumstance of undergraduates where there's had to be a switch to online courses because of the coronavirus pandemic. And I think it might be quite difficult to run an argument to say I should be paid, I should get £3,000 back because it will only cost me if I go to the Open University that, because you're not comparing like with like, are you? But
where I think, yeah, I mean, I think that's a good point, but where I suppose you're going to get there'll be real difficulties is where the university does offer in parallel online courses to in-person courses. I mean, I can think of some, perhaps not necessarily in university, but postgraduate courses in law, for example, where it's quite easy to draw that direct comparison. And there, I think that universities will be under considerable pressure to make refunds, and I know several have. And of course, the added in sort of pressure on universities to be reasonable is the last thing they want is for regulatory action to be taken, and the OFS and CMA down the line to start looking at how compliant they are with consumer regulation under Part 2. So they will come under increasing pressure, it seems to me, to make some sort of refund if you can draw the kind of comparisons that are set out in that question.
Yeah, I mean, if it's kind of exactly the same, and in reality you get exactly the same, then the argument for a refund becomes almost overwhelming. But it's got to be the same, not this looks like it's the same thing but it's cheaper somewhere else. Yeah. We would all agree about that. Well, I think those are all the questions. I want to thank my panelists, Yaaser and James, and I also want to thank you. You may well have only been listening to this in order to escape the dreaded homeschooling for an hour or so. We hope we've provided you with some entertainment and some insight. So I'm saying watch this space, or we've got 2 further seminars about education issues in the next month. One, a crossover with our property law team about property rights and universities in the pandemic and the rent strikes, and the other in respect of the exams, the public exams for GCSE, A-levels and technical and vocational qualifications, something which Yaaser and I spent quite a lot of last summer trying to unravel and deal with. So we've also got a seminar about that, which we're going to be doing in the middle of February, about the way in which they're going to be assessed this year. So thank you all very much for coming. I'm most grateful for you having taken your time to do so, and please do come to further of our seminars. Thank you all very much.
Thanks, everyone.
Thank you.